Hello, welcome to another episode of the Law Review at the Law Office of Riley and Ayler PC. I'm your host, Jacob Ayler, here to answer your questions and talk about topics in the law that interest you or things that you just want to learn about in areas such as estate planning, business, criminal defense. Tonight, this is my first episode digging into one topic that I get a lot of questions on. And this week I had a gentleman come in, and I thought it was perfect for a first episode to talk about. I had a gentleman come in, and he knew he needed an estate plan done, but he didn't know what. And I thought that this was a perfect opportunity to highlight some of the misconceptions that are out there to allow you to make the best informed decision for you and your family. I often hear from people, hey, I don't have a lot of money. I just have a house and $10,000 in the bank. I don't need anything fancy. I just need a will, and a lot of people think that in order to need a trust, you must be a multimillionaire with hundreds of thousands of dollars and acres of land. And a lot of people think that if you don't have sophisticated assets, you should just need a will. And that's very dangerous thinking for people that don't know otherwise. And so the two main paths of estate planning that people tend to fall into one way or the other is either the route of going to probate, which is the court's way of transferring property from one person who is now deceased to their heirs through a judicial process. And then there's the probate avoidance avenue, which is where you see a lot of transfer on death, transfer beneficiaries, trust agreements, those sorts of things. And that idea is that I don't want to go through probate, so I want things to pass automatically to individuals and out of the eye of the purview of the courts and our public court system. And so I often tell people, you have to make that decision for yourself. One big benefit to going the route of a will is if you have a family situation where people don't get along and you might have kids that fight, or maybe you have one child that's always jealous of the other children and it's going to become a problem. A will may not be a bad way to go because you can have your estate supervised by the court and get directions so that everything is done legally, fairly, and that people follow the court's orders. If, on the other hand, you know that your children get along well and you really want to keep things private, the route of a trust is a good way to go because you can keep these things out of the court systems. You can deed your house. You can transfer the name of all of your assets, including your bank accounts, investment accounts, into a trust. Because the nice thing about a trust agreement is it's a piece of paper. And a piece of paper, unlike you and I, will never die. And you can allocate who is going to take what from your trust account. And it allows for more flexibility. The other thing about a trust agreement that's really nice is it allows you to set up contingencies for things like grandchildren. For example, if you have $500,000 and you have grandkids, it may not be a bad idea to specify how those funds are going to be allocated, because it's a really bad idea to give an 18-year-old $200,000. In 6 months, they will have bought a Corvette and probably gotten a couple tattoos, and before it's over, there's not going to be anything left. So these are just some of the things to think about. What I always recommend to every person is go into your estate planning consultation with an open mind and find an attorney who is not just going to tell you, hey, you need a will or you need a trust. Ask them why you need a trust. Ask them why you need a will. Because no two estate planning situations are the same. What I would ask everybody to do prior to meeting with an attorney is you want to do these three things. You first want to get a list of all of your assets, everything that you own, real estate, bank accounts, investments, family heirlooms. Then you want to get a list of everybody that you would want to receive those items, funds, assets, etc. and that can include places other than individuals. If you want to leave something to your church, if you want to leave something to an organization or a charity, that's also an option. And then the last thing you should do is you should put some real thought and effort into who do you trust to administer your estate. Somebody that knows your intent, somebody that is trustworthy, that you don't mind putting in place of your assets. So I would advise you to do those three things, and then sit down with a lawyer who has the heart of a teacher, who's going to explain these things to you so that you know what direction to go. If you have any questions, always feel free to give me a call at the office, 219-866-3435, or shoot me an email, jacob@michaelriley.lawyer. Until next time, we'll see you later. Thanks.